Welcome back to Lostash channel. My name is Anton Bieltsin. I'm a criminal defense attorney in the Southern District of California here in San Diego. It is not every day that you see a case in the appellate court where individual proves actual innocence. In this case, we're going to discuss felon in possession charge under federal law. And this individual was able to show that his prior felony conviction in state court cannot be used as the predicate against him in federal court under felon in possession. Today we're discussing United States versus Hisey, a 10th Circuit case from 2021 that deals with felon in possession. In this case, Mr. Hisey was charged and convicted under 18 U.S.C. 922 G1, felon in possession. In order to be convicted of this crime, he has to have a prior felony conviction. Now, under federal law, we define such conviction. It is a prior crime punishable by imprisonment of a term exceeding 1 year. That makes sense. That's what we generally think of felonies, any conviction over 1 year. Now, in this case, Mr. Hisey has a prior from state court, from the state of Kansas. In 2016, he was convicted for possession of a controlled substance in Kansas. It is very common for my clients to have priors from state courts. And so federal judges often have to interpret state law. In Kansas, in order to be convicted of a possession of controlled substance and later sentenced, the judges use a grid that's similar to federal court. They have a grid that looks something like offense levels on the left, criminal history on top, and the intersection of those two in the middle will give you ranges in months. Very similar system to the federal one. And so in state court in Kansas, using this grid, Mr. Hisey had a presumptive range of 28 to 32 months of custody in prison. Now, unlike the federal system, in Kansas, the court had to impose, they must impose a sentence outside the grid if a number of items are checked off. For example, there's 4 of them. If the individual is lawfully in the United States, if he's convicted under 215706, the statute in Kansas, if the presumptive range is in the V.C., V.I. range, and if there's 2 assessments for drug abuse. Now, this might be very confusing if you don't practice in Kansas, and I don't, but that's not the point of this video. Mr. Hisey had all of these checked off. He fit in this criteria. That means the court had to impose a sentence outside of the grid. He could not get 28 to 32 months. And in fact, that's exactly what the court did. They imposed a drug treatment instead of prison time. Now, when we get to the appellate procedure, to the appellate court, the government argues that there's a word punishable by a term exceeding of 1 year, which means that it doesn't mean that Mr. Hisey specifically received over a year. It is that it is punishable, meaning that it is possible for the court to impose a sentence over 1 year. And after all, his presumptive range was 28 to 32 months. But that's not what the 10th Circuit says. The 10th Circuit goes through the analysis, and here's what they say. The word punishable, that's true. It means that it could be imposed. But in this case, the only way Mr. Hisey would have received a term of over 1 year is if probation would have been revoked. Because we know the court did not have discretion. It said must impose outside of prison grid. That means that they have to give a sentence outside of that prison term, which is what they did. If the probation would have been revoked, it is possible that Mr. Hisey could have received 30 months of prison time. So let's take a look at some other arguments that the government makes. The maximum punishment here is 32 months, but we already discussed that. Even though that's the maximum on the grid, that's only the presumptive sentence. In this court in Kansas, they had to impose something outside of that grid. So this argument by the government fails. In terms of revocation, only if Mr. Hisey's revocation happened, he would have received another sentence. But we know that that didn't happen. By the time he's in federal court, his state probation was not revoked. And even if it would have been revoked, there's a number of items we need to look at. There's other statutes in Kansas that tell the judges what to do if they need to revoke the probation. And if probation is revoked for the first time, it tells the judge to impose a sentence of 2 to 3 days of custody and modify the conditions of release. And even if there was a third revocation, then the grid tells the judge to impose a sentence of 120 to 180 months. And finally, when we're revoking probation, the state judge retains that discretion to impose any sentence that he wishes or she wishes. Which means that even if all of these would have been true, it is unlikely that Mr. Hisey would have received any sentence above 1 year. And finally, the 10th Circuit concludes that none of these contingencies, meaning any of these revocations, actually materialized by the time he was convicted here in federal court. On the day the court could impose a sentence over 1 year, they didn't, because by the time we're in federal court, it is years after 2016. We're in 2021, and we know that a lot of time has passed and none of the revocations materialized. For that reason, the 10th Circuit says that Mr. Hisey, in fact, does not have a felony conviction, a prior, that is punishable over 1 year. And for that reason, the 10th Circuit says that Mr. Hisey actually proved actual innocence. No jury could have concluded that he's a felon in possession because, after all, he's not a felon under this definition. Hopefully you enjoyed this video and you now understand a little bit more about federal felon in possession charge. If you enjoyed this video, please click like, subscribe, hit that bell notification button so next time I post, you'll be first to know.